I'm honored that in my capacity as the director of Nani Palkhivala Arbitration Center, I have been invited to deliver the welcome address. A word about the Palkhivala Arbitration Center. Nani Palkhivala Arbitration Center is a non-profit company founded by the Palkhivala Foundation in memory of India's legendary lawyer, constitutional law expert, orator, statesman, and author Nani Palkhivala. It was founded in the year 2005 and aims to provide world-class arbitration facilities in the area of institutional arbitration. The purpose of establishing the center was to provide quick, efficient, and cost-effective arbitration services and to disseminate information relating to these. The center is also working closely with judicial authorities and with the government to not answer the needs of quick and effective dispute resolution. The ease of doing business index measure regulations directly affecting business. The nation's ranking on the index is based on the average of 10 sub-indices which are set out below. One is starting a business. The second is dealing with construction. The obligation of the legal profession is to serve as healers of human conflicts. To fulfill this traditional obligation of our profession means that we should provide the mechanisms that can produce an acceptable result. Like what we are facing in India was facing the problem of tremendous backlogs. However, in 1984, this is commonly called in US as the Civil Rule 16, which now makes it mandatory for all litigants to pass through a system of alternate dispute resolutions before they are taken up by courts for adjudications. These measures resulted in a huge number of cases being shipped to the association. Through its nearly 35 centers, handles almost 3 million cases a year. This is the model that India hopes to replicate with appropriate modifications to suit our conditions. There is an urgent requirement to collectively work for the success of this effort and hope that the system of alternate dispute resolution becomes so successful that the traditional court system becomes the alternate dispute resolution system. That's our aim, and that's what we should work towards. In India, on account of certain welcome legislative amendments initiated by parties, and after the recent amendments to the Arbitration and Conciliation Act 1996, and importantly, with also passing of the laws which have now made commercial courts possible in India. Before the amendments to the Indian Arbitration Act, India's aspiration to become a major holistic arbitration was constrained by a largely ineffective act and arbitration regime. When we talk about Singapore being a much preferred destination for arbitrations, one aspect that is highlighted, and possibly inordinate emphasis is laid on that, is the technological facilities that are provided by centers there, the fact that courts do not interfere with arbitration awards, the effectiveness of the arbitration procedures, a panel of very competent. One aspect which is lost sight of is the fact that the Singapore government and the lawmaking body there is very, very conscious of the changes that need to be tracked as far as arbitration law is concerned. And between 2000 and 2016, the Singapore government brought in 6 amendments to the Arbitration and Conciliation Act so that you don't allow these things to exist in a state of confusion. Unfortunately, many of the Indian judgments, High Court judgments, have thrown a spanner in the works as far as arbitration law is concerned. And it is our fond hope that of the economics and said, please call off the examination which is scheduled for tomorrow because the question paper has leaked and all the students know the questions. The dean smiled and answered and said, don't worry about it. In economics, every year we change the answers. While it may be so for economics, that's not how it should be in law. In law, you must understand that confusion, just take the confusion with regard to Bhatia International and application of Section 9 and interim measures to these confusions to fester and must find quick solutions. And this is what we attempted to do, and the Law Commission set up this committee to go into the amendments to the Arbitration Conciliation Act. Arbitration and how effective they are. I will just refer to certain observations that existed before these amendments came into effect. The effectiveness of the amendments itself is to be tested because many of the questions are still to sit back, hoping that there will be some smooth resolution of these problems. that this is what the known by the International Arbitration Association. Indeed, arbitration clauses are not only advisable, they are perhaps necessary. This is because the ordinary civil courts which would entertain a suit or breach of contract are so badly clogged with backlogs that it can become pointless to pursue these remedies. Added to that are ad valorem fees payable upfront in civil suits. In most cases, the principal disadvantages of arbitration. So one part of the IBA note prescribes arbitration as a remedy for disputes that may arise in India, but it also cautions the lack of a pool of trade. The list of disadvantages. The tendency to conduct arbitrations like court proceedings in terms of rules and procedures. Recently, I had occasion to judge that many of 34 applications to set aside an arbitration award arises from the simple fact that a high court judge or a district judge before whom these matters come up tried to read those awards like a judgment. This is not written by judges. In many cases, you may have lay persons writing an award. If you are going to apply judicial standards to set aside, possibly 85% of all those awards would require to be set aside. Now, this is a mindset that has to be changed. And the IBA also cautions the business community that arbitrations in India proceed like court proceeding in terms of rules and procedures. The absence of strong domestic arbitration institutions and local arbitrators and the bar not in sync with the best practices of international commercial arbitration. These are things that we are attempting to change in India. ASSOCHAM, in its report, says sums ranging in billions of dollars are leaving India every year in arbitration costs headed overseas, with Singapore the most popular site for arbitration cases filed by Indians. SIAC, 36% of all disputes pending before SIAC are from India. Scores of projects worth more than 4 trillion rupees, that is approximately $64 billion, are under litigation in different courts and tribunals, the report said. Delay in timely disposal of high-value cases is leading to a drop in GDP, which is Secretary General of ASSOCHAM. If it could be tackled, it would expand economic activity and provide new avenues for jobs. Now, the Law Commission report, the 253rd report of the Law Commission of India, which dealt with commercial courts, also said the concept of commercial court, a dedicated forum aimed at resolving complex commercial disputes, from the fact that around the world, many nations have adopted commercial courts as a means to ensure speedy delivery of justice in commercial cases. A more elaborate discussion covering many countries that have set up the report of the Commission, and the same is not being repeated here for the sake of brevity. However, it will be worthwhile to briefly restate the justification for a commercial court in India. The importance of a stable, efficient, and certain dispute resolution mechanism, just compensation for damages suffered, are absolutely critical to investment and economic activity, which necessarily involves the taking of financial and enforcement risks. A stable is therefore essential to the economic development of any nation. Then, it also points out that for investors and companies that India is a difficult place to do business. Inter alia, for contract enforcement takes 1,420 days, nearly 4 years, and costs of enforcement aggregate to nearly 40% of the value of the trade. Since the World Bank first started the services of its in 2004, that was before the Law Commission, when it was charged with the business of suggesting to plug the loopholes in the Arbitration Conciliation Act 1996 and suggestions for a law that set in place a regime for commercial courts. These were the figures that were available in 2014, and the effort of the Law Commission was to bring out laws which will ensure that we have a good regime, that we have at least a law in place. Once the law is set, it does not mean that a magic wand has been waved and everything is going to become apple pie. That doesn't happen. Once the law is in place, then the institutions will have to be aligned to meet the mandates of the law. Whether that happens is the challenge before us, and what we at Nani Palkhivala Arbitration Center are working towards. The positive aspect, of course, is that a recent report by Ernst & Young revealed the following. 70% of the survey respondents highlighted that arbitration clause is an essential part of the legal contract. I'm talking about a survey done in the business community, which said that 74% of them said that they took care to incorporate an arbitration clause. Type of arbitration, the survey highlighted the mixed usage of arbitration mechanism. Out of the total of 20 respondents, 24% of the respondents have undertaken Indian ad hoc arbitration. Now, this is another big problem that we face. A majority of the arbitrations that happen in India are ad hoc arbitrations. Now, this is not the way to go for reasons which will be debated during the course of this conference. We need to go towards move towards institutional arbitrations so that the regime of arbitration improves substantially. But the sorry aspect is that even today, a large percentage of arbitration pointed out to the fact that the importance given by the government of India to the improvement of arbitration mechanism. More than 50% of the respondents said that the ministry's recent steps to develop dispute resolution mechanism are in the right direction. Therefore, industry is also taking note of these new changes that are going to come through amendments to the Arbitration Conciliation Act and through the Commercial Disputes Code going to be set. Then enforcement of the arbitral award, 78% of the respondents revealed that they were satisfied with the arbitral award. Cost and time disadvantage, around 50% of the respondents state that arbitration in India is expensive and does not provide timely resolutions, which highlights the need for radical changes in procedural aspects. Arbitrator selection, 68% of the respondents believe that subject matter experts should be appointed as arbitrators, as against 22% who believe that retired judges should play this role. Therefore, we see that there is greater requirement for experts in institutional arbitration. Taking into all these things, I'm just going to highlight a few of the important changes which the Arbitration Conciliation Act 1996 has brought out. One is arbitrators' neutrality. It is no longer possible for companies to nominate their own employees as arbitrators in an arbitration for an arbitration. That aspect of the law has completely changed, and therefore, hopefully, now we will be moving towards arbitration proceedings, and one that is seen to be not only fair, but is also seen to be fair. Happened is that the fees of arbitrators, now that was a matter of great concern. In fact, the Supreme Court itself had occasion to observe in Union of India versus Singh Builder Syndicate. There is no doubt a prevalent opinion that cost of arbitrations becomes very high in many cases where retired judges are the arbitrators. The large number of sittings and the charging of very high fees per sitting with several add-ons without any ceiling have many a time resulted in the cost of arbitration approaching or even exceeding the amount involved in the arbitration. So this is an observation by the Supreme Court itself about fees in arbitration. So what did the Law Commission do to address this? The Law Commission has inserted Schedule 4 under Section 1114 prescribing a model fee and making a scheme for the High Court to frame rules accordingly. This provision is not made applicable to international arbitrations and for institutional arbitrations. The third is that there is a time limit now imposed on the resolution of disputes through the arbitration process. Now, that has become a little controversial. A lot of people are saying that these timelines are completely impractical, especially in terms of international arbitrations, and others who say no. There's a bit of a controversy about it, and others who say no, it is possible to dispose of arbitration agreements, dispose of arbitration disputes within the period that has been stipulated. We need to see how that evolves. My own feeling is this can be resolved with a full amendment which says that subject to the agreement between parties, this section will apply. And also having a provision which it should be possible to resolve this aspect of the matter. Third is amendments have improved the climate for international arbitration, especially with regard to amendments to Section 9, 27, 37(1)(a) and 37(3), that is, provisions relating to interference by courts, court assistance in taking evidence and appeal, even if the place of arbitration is outside India and enforceable under Part 2 of the Act. Another important change that has been brought in international arbitration is that all applications to court has to be made to the High Court having jurisdiction rather than the principal civil court in the district. So, setting aside an international arbitration will now happen only in the High Court. Previously, it could go to the district of an arbitration award that has been passed, and that is a huge improvement because it can result in proper security for whatever amount has been awarded so that the person who wins and has an award in his favor is hopeful that at least he will be able to realize the money that has been awarded to him. Then the problem posed by as we all know, is an unruly horse, and it has been rampantly unruly in India before in violation of public policy. If you look at the numbers, it's actually very low. It's possibly, I think the number was 3% of all the challenges to the award. Only 3% have been set aside on the basis that they have been in violation of public policy. But then it gives us a huge bad name. It says that in India, if you go and file something, it can be set aside on the basis of public policy, which really in its practical application is not true, but then it has given us a bad name. So that has been amended, watered down substantially. So these are the changes that the amendments have brought up, that the international community, the international business community will look on India as the most favored destination. Go into how actually we give flesh and blood to this concept of institutional arbitration and set up these centers with these changes and shift in terms of improving the climate for arbitration, not only in respect of international arbitration, but also in respect of arbitrations, because the court system just cannot take the type of backlogs that are prevailing. There is some statement that if no new cases are filed in India, it will take 300 years to dispose of the existing backlogs. Recent report which even if judges work 24 hours a day with no new cases being filed, it will take them at least 40 years to dispose. We are hoping to set up an environment not only to make in India, but also to resolve in India. Thank you all.